Okay, now
Good afternoon.
speech in Kenya.
What time are we starting?
The invite said 6:30.
Ready.
Good afternoon and good day to everyone on the platform.
Ready.
The Jamaican High Commission is delighted to collaborate with the Jamaica Legal Network UK to host this virtual seminar entitled "It's All About Land" on how to acquire, register, and transfer land in Jamaica. Now is the time for Jamaicans in the diaspora to invest in themselves by investing in Jamaica. This is an exciting time. We're enjoying record low unemployment, low interest rates, and inflation. Real GDP has expanded by 2.9% in the first half of 2023. And against this background, Jamaica is now experiencing a boom in the real estate market, which provides a safe investment. We are grateful to our speakers, Miss Simone Bowman and Miss Nastasia Boyd, who are both attorneys at law with expertise in land matters. We have also arranged for us to hear from the National Land Agency of Jamaica in the personage of Miss Nicoy Young, who is responsible for land administration, and well, rather, the National Land Agency is responsible for land administration and management in the country. Land is a precious resource that can affect your legal and financial rights. Land and property rights are essential for the economic and social development of Jamaica. It provides security, or rather, security incentives and opportunities for investment, entrepreneurship, and livelihoods. However, many Jamaicans lack formal documentation or clear title to their land and property, which exposes them to risks of eviction, disputes, and marginalization. Having the right information about land and property rights in Jamaica can help individuals and communities to access, manage, and protect their assets, as well as to participate in decision-making processes that affect them. Therefore, it is essential to know the steps and requirements involved in land transactions in Jamaica. In this seminar, you will get useful information and tips from our speakers, as well as the opportunity to ask your questions and clarify your doubts. I will now hand over to Ms. Simone Bowman, a seasoned legal practitioner with more than 2 decades of experience. She's a qualified attorney at law in the UK and Jamaica, as well as several other Caribbean islands. She was a postgraduate certificate of legal education from the Norman Manley Law School, University of West Indies, which she obtained in 2017. She will anchor this webinar and share her insights and expertise with us.
Your Excellency, thank you very much, and welcome to everyone that's listening, that's viewing us on the YouTube. A very, very warm welcome. Jamaica, land we love. It's what we hear in our national anthem, and we're reminded that if we want a piece of Jamaica, or we want to understand land a little bit better, it's important that we understand the processes involved, the procedures involved in acquiring land and acquiring a title. We have Mr. Nicoy Young, who is going to be our guest speaker, as you've heard, and he's a manager from the National Land Agency. And the National Land Agency is an executive agency of the government of Jamaica and falls under the Ministry of Water, Land, Environment and Climate Change. It brings together the core land information functions of government under one roof, which includes land titles, surveys and mapping, land valuations, and estate crown land management. So we're very pleased to have Mr. Young with us today. Also, we have another presenter, Ms. Nastasia Bowen, and she's here today to provide an insight, knowledge on land matters, and will give us an overview of the buying and selling of land in Jamaica. It's the buying and selling of real estate. She's an attorney at law who was called to the Jamaica Bar in 2021 and a graduate of the Norman Manley Law School, like myself. She is an associate of Bowman Law Caribbean and practices in immigration, conveyancing, and estate planning, and also studying for the New York Bar. So we're very pleased to have her with us today. Ladies and gentlemen, I present to you Miss Nastasia Bowen. Over to you, Miss Bowen.
Hey.
Good afternoon to you.
Good afternoon. Hello, everyone. As you just heard, I'm Nastasia Bowen, and today I will be presenting on the conveyancing process of land, specifically in Jamaica. So that is the buying and selling process. I created a PowerPoint, so we'll go through the PowerPoint together. And like the panel just said, you are welcome to input your questions in the chat box below, and then we will answer them at the end of the presentation. All right. So conveyancing is the exchange or transfer of real estate. So that is to transfer or deliver land or property to another, or to perform an act that is intended to create one or more property interests, regardless of whether the act is actually effective. And in Jamaica, the usual means of transfer is by a deed-written instrument on paper. So there are 5 stages of the conveyancing process. The first stage is the pre-contract negotiations. So this is where the buyer and the seller, they negotiate potential offers. And at this stage, it is also crucial that as a potential buyer or seller, that each party knows or gets adequate information about the land that is being sold or bought. The parties at this stage must also discuss and agree to any and all conditions, such as the date when the contract is to be exchanged and the completion of the contract. The objective at this stage is to arrive at all the terms, especially the price and the extent of the property that is being sold and conversely bought. And the parties, they must also agree to any and all terms at this point of the conveyancing process. The second stage of the process is where we exchange the contract. So after the parties agree upon all the terms, the services of an attorney should be utilized to draft the sales purchase agreement. So each party's identity must be verified, and the attorneys must check for conflict of interest before accepting a party as his or her client. Most attorneys in Jamaica will insist on receiving written instructions from the client. At this stage, it would be prudent for the buyer to perform some steps such as securing a mortgage commitment if it is a sale by mortgage. It is also important at this stage to make searches at the title records, and NLA will go into this further. But basically, what this ensures is that the person who is purporting to sell the land that they are actually capable of doing so. A title search will also help a prospective buyer to unearth information regarding whether there are any encumbrances on the title, because solely looking at a duplicate certificate of title will not necessarily give you all the information that you need, and it is advised that it is unsafe to solely rely on this piece of document. Also, let me try to, okay. Also, the contract you are also supposed to secure an insurance, because most times at the stage when the contract is being exchanged, the risk also changes from the seller to the buyer. So securing a property insurance at this stage also enables a shield for the buyer against any unpredictable events, because we're in the Caribbean and things happen every day. Just yesterday in Jamaica, there was an earthquake. So an insurance is also crucial to get at this stage of the process. And at this stage, you also want to secure your security deposit. So the contract is then prepared by the seller and is sent to the buyer or their attorney for signing. And at this point, it is customary for all the parties to negotiate the terms until all are resolved. The next stage of the conveyancing process is the pre-completion procedure. And this stage is marked by following the formalities being completed. So the agreement at this stage, once it's signed by the parties, is submitted to the stamp duty office to be stamped. You also pay the transfer tax, and usually the cost for the stamp duty is split between the purchaser and the buyer. After the another step of the pre-completion procedure is that, as I earlier stated, conveyancing can be done by cash or by mortgage. So if you are financing your purchase by mortgage, at this stage, you would also sort out the kinks of the mortgage. So if a third party funds part of the purchase price, that is the grant of a mortgage, then the buyer or the purchaser would immediately take steps to finalize his mortgage arrangement, get a letter of commitment that is presented to the seller. And if it is an all cash transaction, then the buyer pays the balance of the purchase price, and both the parties execute the instrument of transfer for presentation to the office of the Registrar of Titles. And following the pre-completion stage is the completion stage. And at this stage, all the documents are signed and submitted to the office of the Registrar of Titles. Once the title is registered, a buyer may arrange for any last-minute inspection of the property to ensure it matches the description when the contract was first entered into. And also, I forgot to mention earlier that while you're exchanging and negotiating the terms of the contract, it is also prudent as a prospective buyer that that you obtain a pre-inspection engineer's report, because this report will help you to make an informed decision in deciding whether or not this is the land that you want. Because a lot of times, a certificate of title or just looking at the land alone is not sufficient to know if the land will be profitable to you in the end. So an engineer's report is also prudent. And at the completion stage, it is also important that you conduct a later inspection of the property to ensure that it does in fact match the description when the contract was first entered into between the seller and the buyer. Also, after the transfer is registered, you, as we know, are then the owner of the property, irrespective of whether it is mortgaged. And the time for completion of the first three stages, that is the pre-negotiation, the exchange of the contract, and pre-completion, It usually takes 90 days if it's a mortgage transaction. And if it's a cash sale, it is customary to allow 45 to 60 days for completion. The amount of days will be determined by the buyer and the seller when they're having their pre-contract negotiations. So at this point in the sales process, the buyer's attorney will have prepared letters and address them to various utilities companies, so like JPS, NWC, the land tax office regarding the transfer, and for various utilities to register or commence service in the name of the buyer, now the owner of the property. And you must ensure that the final utility readings are done. As the seller, you must ensure that the final utility readings are done so that you are not being billed while the new owner has possession of the property. And the final process of the conveyancing process is the closing. And this is where the buyer's attorney ensures that the transfer is completed and the duplicate certificate of title is accurate. Further, the title will reflect the discharge of any prior mortgage and the accuracy of any new indebtedness or mortgage. And the owner at this stage will be given their certificate of title or a certified copy of the title if the lending institution keeps the original certificate of title. And the post-completion process, it usually takes anywhere from 2 to 3 months. So, just to reiterate before I turned over back to Ms. Bowman, the conveyancing process is the buying and selling of property in Jamaica. There are 5 stages to the process. The first stage is the pre-contract negotiations. The second stage is the exchange of contracts. The third stage is the pre-completion procedures. The fourth stage is the completion, and the final stage is the closing or post-completion. Conveyancing in Jamaica is heavily attorney-driven. So although the process, it appears to be very simple, it's a lot of paperwork. So it is recommended that if you are interested in selling a piece of property or buying a piece of property, that you acquire the services of an attorney, because the process can be quite intimidating. Ms. Bowman, back to you.
Thank you, Ms. Bowman. Thank you very much for that overview of the buying and selling process in Jamaica. And I'm really pleased that you highlighted the real significance of pre-purchase inspection, such as getting the engineer's report. I know that many people decide to bypass that for whatever reason. It could be a cost issue. Several reasons. But we cannot stress the importance of obtaining inspection reports of your property pre and during the completion stage. So thank you for that overview. We will be taking questions. So I know some of you have posted questions in the chat box. So we will get around to answering your questions. So if you want to have any question answered, please do feel free. Those of you on YouTube, I believe there is a function for you to ask questions as well. Okay, so we're now going to hear from Mr. Young, who, as I've mentioned before, is a representative of the National Land Agency. And you will hear us perhaps throughout refer to the National Land Agency as the NLA, and that's just a shortened version of how we refer to them. So, Mr. Young, we're really pleased to have you. Are you there with us? See if we can.
Good afternoon. And
good afternoon to you, Mr. Young.
Good afternoon, and thank you. Thank you for inviting me to be a part of this platform. And I trust and hope that whatever information is shared, you'll all find it quite useful. Now, I want to start out by highlighting a few things, namely the fact that land in Jamaica falls into two categories, which is registered and unregistered. So some of the properties do have a title and some don't. Now, for you to get your property, let's say your land doesn't have a title. We would like for it to be titled. You need to show your root of title. Or how is it that you came to be the owner of the land? Or why is it that you should be considered the bona fide owner? Now, as was said earlier by counsel, in a lot of instances, persons who are in possession of land, the formalities are not observed. So, I am to get a parcel of land from my father, but he did not give me a deed of gift. He just said, son, go and build on that parcel. Or I purchased a parcel of land and I might have had a little receipt, or that is adequate. But in a lot of instances, the documentation is not in place. Or you purchased a property that is part of a subdivision, but the release of the lots were not secured from the municipal corporation. So what you'll have is that persons are in possession of land, but they don't have any documentation. Now, in the circumstances, what is it that you have to look at? In trying to get a parcel of land registered, I need documentation to show my ownership. You should be paying the taxes, but it is not an indictment or it's not a major issue if your name does not appear on the tax roll, because you might have the tax roll might represent the names of the previous owners of the land. You should have a survey diagram, and this is what you'll get from a commissioned land surveyor. The lifespan of a survey diagram is 7 years, and if it surpasses 7 years, you can retain the services of the said surveyor to get a surveyor's declaration, and that will update the survey diagram for a further 7 years. So you don't necessarily have to resurvey the land. You just particularly have to get a surveyor's declaration to update the diagram for a further 7 years. Now, what you can look at in terms of your documentation to show ownership, you can submit your receipts, your sale agreement, deed of gift, or your deed of conveyance. Sometimes it might be a probate. So you might have gotten the property through a will and it is probated, or even if it hasn't yet been probated, but it's a document that shows your connection to the land. You might have purchased the property years ago and you have you got a mortgage maybe from one of the cooperative banks. You might have a certificate of compliance under the Facilities of Titles Act. So these are some of the documents you might be able to present. Now, once you have the survey and or the surveyor's declaration, you have your tax information and any of the documents that I've made reference to previously, namely the receipts, the deed of conveyance, deed of gift, probate, or your certificate of compliance, you're able to, you're in a position now to apply for title. Now, it might very well be that your property forms part of a larger parcel, and as such, you will need subdivision approval. Subdivision approval is had with the assistance of a commissioned land surveyor, wherein they will survey the property, prepare the relevant subdivision plans for you to lodge with the relevant municipal corporation. Now, why I say relevant municipal corporation? Because this is dependent on the parish that the property falls within. So if it were to fall in St. Elizabeth, then you would be looking at the St. Elizabeth Municipal Corporation. And the same would apply if it were to be St. Catherine Municipal Corporation. Now, once these documents are lodged with the municipal corporation, they'll send them to the other relevant organizations like NEPA and so forth, and you will get the conditions of approval, which you will sign to. And once it is that you comply with all of those and provide them with the relevant documents, then they will, because they'll also give you instructions to put in place like water, road, electricity, etc., dependent on the size of the development. Or sometimes those things are necessary, sometimes it's not a requirement. But what they'll do, they'll give you a release of the lot. Once the lot is released, this is a letter that you receive from them directed to the registrar of titles to say that, yes, you can proceed with title. However, through the Land Administration and Management Program, or division, sorry, you are able to secure subdivision waivers. So it will save you cost and monies once it is that the informal subdivision of the land is more than 7 years old. Now, if it's a property that you purchased in 2021, was surveyed in the same year, which is part of a larger parcel, you'll have to approach the municipal corporation or to get the subdivision done, or you would have to retain the services of the surveyor, thereafter lodging or submitting to the municipal corporation to get the subdivision done or approved, because in the circumstances, your informality would not have been 7 years old, and we only grant the waivers to persons who have informal subdivision for more than 7 years. Now, if it is that the property, you have all of these things in place, then you can visit us, and our primary parishes are, I'm going to say it as best as possible. If you have properties in St. Catherine, excluding Portmore, but within Portmore, we have Noggerhead, which is included. Portland, St. Mary, St. Thomas, and areas in St. Andrew, Lawrence Tavern and its environment, Rock Hall, in those particular areas, you can retain the services of the Land Administration Management Division to assist you in getting a title. However, if your property falls in the other parishes, namely Clarendon, Manchester, St. Elizabeth, Westmoreland, Hanover, St. James, Trelawney, St. Anne, then you can retain the services of Geoland Titling Limited, because under the government-private partnership, they outsourced all of these parishes to Geoland Titling Limited. So under the same legislation, some parishes fall under the National Land Agency, some fall under Geoland Titling Limited. Now, if you have your attorney at law, and you desire to utilize your attorney at law, you can still reap these benefits. So you don't necessarily have to have us directly interface with you. You can utilize the services of your attorney at law just the same. And all of the benefits that we offer, these are things that you can cash in on. Now, some of the times, our clients will come to us and they would like to get a title, but they don't have the documentation in place. Once it is that you are in possession or have been in possession for 12 or more years, then we are able to assist you. Having prepared the application, we'll submit the matter to adjudication. What do I mean by adjudication? Adjudication is a committee of 5 persons, which constitutes a commissioned land surveyor, a justice of the peace, an attorney at law, a community representative, and a minister's rep. And these 5 persons will listen to your evidence. Once they are satisfied that you have been in possession of the land and your possession is not in dispute, then what they will do, they will issue you with an adjudication certificate or record of decision. Now, once this is issued to you, your matter is not referred to the referee of titles. It goes directly to the registrar of titles. And once everything is satisfactory, within 28 working days, you should get your title. So it's not advertised. It doesn't go to the referee for it to be adjudicated on, because all of that is done during the adjudication hearing. It is not a court setting. However, you will be asked questions, and once you answer those questions satisfactory, then the committee will approve your application. Now, for you to apply for title, once you have in place the property tax certificate, your survey diagram along with and/or the surveyor's declaration, any document that proves your ownership, you also need the names of 2 persons who can support your application. We would rather for them to not be relatives. They should be at least 50 years or older, and they must be able to give an account of a 30-year history of the property to say that they have known it for upward of 30 years, and this is how the property changed hands over the years. And you must be able to give a 40-year history of the land. Now, some of the times you might have on the tax roll Noel Rhymes. But Noel Rhymes is my grandfather. I inherited the property from my father, but then I sold the property to Milton Myers. So what will happen? In Milton giving a history of the land, he will have to get the information as to who was Noel Rhymes, to move it along the line, to come to me to show the link, for, to show that the relevant tax certificate is what should be accepted. Now, as I said, if it were to be part of a larger parcel, you need a subdivision. So once this information is with us, then we are in a position to open your file and to assist you with your title application. Now, usually the application is submitted to the referee, and the referee can can either provisionally approve the application, or sometimes they'll reject the application and ask for additional information. They might ask for you to explain points in your declaration, or for you to provide them with additional evidence. Once you comply with that to their satisfaction, they'll issue you with the provisional approval, notice of provisional approval. This is for the property to be advertised. Sometimes it is for you to advertise with the Gleaner or the Observer, or sometimes it is also for it to be advertised in an international newspaper. It does happen. Now, once the application is advertised, the advertisement period can be 6 weeks, the break period 6 weeks, and the 6 weeks is for persons who might see the notice to come and object to a title being issued to you if they think that your application impinged on their ownership or property that touches and concerns them. Or it might be advertised for 3 months, 6 months, and sometimes it can go up to a year based on the RTA, the Registration of Titles Act. Now, once you have advertised the property and the relevant caveat period elapses and there are no objections, then you can now proceed to pay final fees. And once the final fees are paid, and you submit the tier sheet, that is the notice from the relevant newspaper, then within 28 working days, you should get the title, provided there are no other issues with the application. So these are some of the things you should bear in mind. But there is also a limb that is of concern to a lot of persons, and this touches and concerns adverse possession applications. Now, the land is registered. There is already a title for the property, and the property is left unkept. Now, what I would recommend, I recommend strongly that once you have your property, you ensure that you appoint someone or grant someone permission to look over your property, because once you leave the property unkept for 12 or more years, a person can enter upon your property, even though they would be a trespasser, and they can claim your land, applying for title after 12 years. Now, if it is that you notice that persons are trespassing on your property, what I would recommend is that you send them a registered notice. And once you send a registered notice before the crystallization of the 12-year period, then it eliminates all the years that they were in possession and start them back at 0. So if in year 10, you send a registered notice to the person in relation to their possession, asking them to vacate your property, then even though when they are there for 11 years, they would have just been there now for a year, because it eliminates the previous 10 years. So what we do ask is that even if you're out of the jurisdiction, is that you ensure that you have someone who is supervising your property, or as best as possible, don't just leave the property there without checking to see what is happening, because it is ending in heartbreak for a lot of persons who have worked extremely hard to secure their properties as per what council had said. You pay your attorney fees, etc., and you paid your mortgage, you finish paying your mortgage, you unfortunately, for whatever reasons, left your property unattended, and someone else occupied the property for the number of years, 12, and then applies for title by way of adverse possession. And even if you were to go to court, in a lot of instances, you're unsuccessful. So we do ask that persons ensure that they exercise conduct and jurisdiction over their properties as best as possible. I was asked to be brief. I trust this was brief enough. I thank you all for listening. And if you have any questions, I will respond to them accordingly. Thank you.
Mr. Young, thank you very much. Mr. Young? Yes?
Yes.
Thank you very much. Your presentation was very succinct and thorough at the same time. So we do thank you very much.
You're welcome.
Yes, I'm really pleased that you touched on what we would refer to in legal terms as adverse possession, and this notion that if you, well, not necessarily notion, but if you occupy a property for 12 years or you're in possession, you can apply via that adjudication process. And I think a lot of viewers would not necessarily know that full process or procedure, but I'm grateful that you outline that process to the viewers listening. So thank you very much. And also, just to pick up on the fact that it's important to maintain your property, and if there is somebody you can trust to look after and maintain, and yeah, just keep the property in good order. That's always helpful. Also, I do get inquiries from persons asking about payment of land taxes as well, and you can actually pay your land taxes online now, so you don't have to ask anybody in Jamaica to, you don't have to send money to Jamaica for that person to then make payments to pay your land taxes. You can actually go online if you're tech savvy, or you can ask somebody to assist you on the tax administration website. So yes, we do have quite a few questions that have come in, and we will do our utmost to answer those questions. And I'm just gonna have those questions sent over to me now.
Okay. Your first question. My aunt and her husband passed away in 2019, leaving a property in Portland with a small amount of land. They did not leave a will. There are no siblings. The property is currently abandoned. How would you suggest I proceed to gain the title to the property if possible?
Okay. So here you're dealing with what we would consider probate or trying to apply for letters of administration. So we will be having a session on dealing with wills and probate and applying for grants and for administration of estates at a later time. I think that's going to be in February, sometime in the new year. So what we want to try and focus on today is questions specifically relating to obtaining title, but not specifically dealing with death or notation of death. Okay, so but I can take that question offline. I'm happy to take that question offline. Thank you for your question. We will be dealing with that in a bit more detail when we come to the wills and probate seminar.
And one person is asking, will I need to have a Jamaican bank account?
for a conveyancing process. No, you don't have to have a Jamaican bank account at all. It's entirely up to you how you wish to transfer funds, whichever you feel is the most secure. If you're going to use the services of an attorney, then those funds can be transferred to an attorney's account. But yeah, it's not compulsory, no. Some purchasers already have bank accounts, and they have a tax registration number, which is necessary to have. Ms. Bowen, did you want to add anything to that, whether it's necessary to have a bank account?
No, it's not. As you stated, it's entirely up to them if they want to get a bank account in Jamaica or stick to their overseas bank account.
Yeah, where the pound is quite strong, I should say.
In your presentation, you did not mention surveyor's reports. Isn't it prudent to produce a surveyor's report to check for encroachments and breaches?
Absolutely. Ms. Bowen, do you want to touch on
Yes.
And
You're absolutely correct. It is very prudent as a prospective buyer that in addition to the pre-purchase inspection engineer's report, that a surveyor's identity report is also received, because like the person who asked the question stated, the surveyor's report, it does give detailed information regarding the boundaries of the property. It also identifies whether there are any breaches to the covenants and the title and whether there are any encroachments. So yes, guys, if you're a prospective buyer looking to purchase a piece of property, you should get a surveyor's identity report as well.
Excellent, thank you.
One person is asking, would you recommend that the same attorney represent both the buyer and seller?
No, I would not.
Yeah.
It happens, but it is not recommended that the same attorney represents both the seller and the buyer, because you want to ensure that at the end of the day, there's no conflict of interest and that your interest is being is paramount and forefront to the attorney who is dealing with the matter. So it is recommended that if you're buying or you're selling, get a different attorney from the other party.
And again, sometimes it comes to this issue of costs as well, and trying to cut costs. So as Ms. Bowen has said, it's really important just to ensure there is no conflict of interest. Instruct your own individual attorneys respectively.
Okay, we have one person who has their hands up, who is Tara Johnson-Reed, who is a member of the Global Jamaica Diaspora Council.
Good evening. Thank you for putting together this presentation. I'd also typed my question in the chat, but the question was around capital gains tax. So quite a lot of us are dual citizens. So for a person who is a citizen of Britain and Jamaica and resident in the UK normally, would they, once they've sold property in Jamaica, would they have to pay UK capital gains tax on that when it crosses the threshold?
Good question. That's not something that I have actually had to deal with at all in terms of capital gains tax. All I would say is that it would be in your interest to declare anything that has been sold or purchased by yourself, just for your tax purposes, whether you're self-employed or not. It's always important and prudent to declare, as is necessary, to HMRC. So yeah. So,
Okay, thank you.
just be cautious. That's all.
There's quite an interest in the different types of reports that might be involved in the process. So one person is mentioning that, as far as they're aware, there are 3 different types of reports. So we've already spoken about engineer's report, surveyor's report. So maybe that could be clarified if that is the case.
All right, so as we've outlined, that the survey report is literally identifying the locale of the land, okay, and it's identifying the specific parcel. The engineer's report is generally looking at the type of material, not so the type of land. If you're planning to build erect a house, you may want to check if the property is situated on rocky land, for example, and so an engineer's report would be better placed for that type of survey to double check. Ms. Bowen, do you want to add anything to that? The distinction. I don't think there's any other reports that I'm aware of. It's just the survey of the evaluation.
So what you just described was the surveyor's identity report. What makes that different from the pre-purchase inspection engineer report is that it has nothing to do with the boundaries per se, or whether there is any encroachment of title, but it is a more detailed report that looks specifically at the land. If it's if you're buying a piece of land, so like the soil quality, whether there is any environmental hazards on the land. If it's a house, it's a structural inspection of the roof, the foundation, the grading, and stuff like that. So that is what makes the two reports different.
Thank you. And also just to add the valuation report as well, which is obviously quite distinct, and as it suggests, it's about the value of the property or the land itself. And that valuation survey is quite critical, because that would be your sort of bargaining power, so to speak. If you've got a price, or you've been given a specific valuation or price of a property, and you want to negotiate, and that survey valuation report rather would be really, really helpful for you. So
Okay,
so a couple more questions.
Yeah, and a couple of them revolve around taxes. This question, this person is saying, my family has a family plot that has been occupied by distant relatives for around 50 years. During that time, the family paid the taxes. Will the occupying family have any claims on the land?
Okay, Mr. Young, would you be able to assist in answering that question?
In the circumstances, you have to bear in mind that possession is what is important. Now, if the property is registered, they would only need 12 years possession. And if it's unregistered, after 30 years, your title to the land would have been extinguished by them. So based on the fact that you made reference to 50 years, I'm not really seeing how you would be in a position to recover possession. So that is a property that, if they are so mindful and they are good family members, if you're interested in a portion and they are open to allowing you to claim a portion, then it's fine. But if you were to approach through the courts, chances are you would be unsuccessful. However, persons must remember that there's a significant distinction between you giving the family members permission. And I particularly like the word permission, because when I grant you permission, it's a case wherein you did not act adverse to my interests. You were there with my permission. So that's a limb that you can explore also.
Thank you for clarifying that.
Yes, if you don't mind me just adding something to the discussion. Something I say, have said too often in my practice. There is no such thing as family land. No such thing. There must be somebody in the family that actually has root of title, and it is for those person or persons to prove that they have actual ownership to the land by virtue of their possession. So just to say that There is absolutely no such thing as family land.
Thank you very much, Commissioner, for that clarity there.
May I?
Yeah, go, yes, please, go for it.
Not disagreeing with senior counsel, but I think in some of the instances, what might have happened is that there are many children. So sometimes you might have the property was owned by the father. He died, leaving 8 children, and as such, they then die, leaving children. But some of them are occupying, so his grandchildren is on the land and so forth. And I think that
Give me a minute.
Yeah.
Mr. Young, you're muted.
Nothing.
my apology.
Just repeat that last sentence for us, please, Mr. Young. From grandchildren.
Yes, I was saying that the property might have been owned by A, but he died leaving maybe 8 children. And as such, these children beget children, thus the property is occupied by children, grandchildren, etc. And as such, you would have to, and some have died over the years, you would have to go through the gamut to see which will to probate, which estate to administer, and parochial is referred to as family land. But us as practitioners will know that it is not really family land. It is really owned by someone, but it is just how it is referred. So I'm happy that council even raised that point.
Excellent, thank you. Right, do we have any questions on YouTube?
No.
We do have another one here. If the owner of the property is deceased in the UK or US, and I'm acting as executor, should the will or letter of administration be probated in Jamaica or in the country of death?
Okay, so that rather depends, and we're not here to give any legal advice, so we tend to we can take that one offline. Unless the High Commissioner would like to, because we have to, especially when persons ask us personal questions, we have to be very, very careful in terms of the information that we provide if we're not privy to all of the facts.
Yeah.
But if
just as a general comment.
please do.
Yes, case of death, and there may be a process of what is called resealing in Jamaica to allow for dealing with the property in Jamaica. So the general position is not exclusive, but the general position is date of birth, have your thing probated, and then it goes to Jamaica, goes through a process of receiving to deal with the assets of property in Jamaica.
And we will be covering aspects of grants and resealing in our webinar in the new year. Okay, so watch this space. Excellent. I think we've got much time. We've got a little bit more time. And one of the topics that we haven't yet covered is dealing with lost title. Mr. Young, is it possible you could give us a very short overview of applying to the Register of Titles under Section 82? And just a basic overview. I know you touched, but just specifically on lost title, if you were able to, in the little time we have left, I'd be so grateful.
Okay, so in certain instances, or in all instances, whenever a title is prepared, the original is held by the Registrar of Titles, and the duplicate is issued to the proprietor. So, whenever the proprietor is unable to locate their copy, the matter is treated as a title that has been lost, but the original is indeed with the registrar. Now, once it is that you have lost your title, and you discover that it has been lost, if it were to be via a fire, then you would have to secure the fire report. If it were to be during maybe like a theft, you have to get the police report to support your application for a lost title. Now, if the proprietor died and the personal representative in the estate is unable to locate the original, the duplicate title, then they'll have to apply for a lost title just the same, detailing the fact that the title was, to the best of their knowledge, with the registered proprietor, or in instances where the proprietor is alive and the title was with a maybe with a third party, then in doing your title application, what you have to do, you have to highlight the fact that the title was in your possession, however, it was sent to this third party, or this third party had possession of the title. You would now have to have a declaration from that third party to support your application for a lost title. Now, in lodging your lost title, there are certain things you have to prepare within it, in the fact that you will be stating that the title is not in your possession, and if it were to come in your possession, you give your honest undertaking to return or to deliver up the said duplicate to the registrar of titles. Now, it's an application that once if it is that you have multiple persons as proprietors, all of those persons have to apply for the title that has been lost. However, if some of them died and the title was held jointly, then you would note the death of those who died first, and the last surviving person, who would now be the bona fide owner. That person's representative, be it his executor or personal representative, could then apply for the lost title application and proceed to get the title replaced. The application has a few intricate parts, in the sense that it says that if you were to locate the title prior to the completion of the lost title application, or the new title being issued to you, that you undertake to deliver same to the registrar. And if it were to be found after you have received the new duplicate, then you will still deliver same to the registrar. So that's a quick synopsis in relation to the lost title application. Bearing in mind that once you allege that a third party had access or intermingled with the title, then that person will have to give a declaration to state that the title is not in their possession, etc. Hello?
Yes.
Thank you, Mr. Young, for that overview. Much appreciated. I know that the listeners and the viewers will have appreciated that overview. So thanks.
Going to Shirley Samuels, who has her hands up.
Life Radio.
Live radio.
Is it Life Radio first? Okay.
We have a question from Live Radio UK. Good evening.
Yes, good evening. My name is Mike Johnson.
Welcome.
I previously asked that question about registering the will in the UK or in Jamaica, because my family is going through that. They probated the will in the UK and then have it to reseal it in Jamaica now. So it's a double expense, basically. But if a title shows, or engineer's diagram or surveyor's diagram shows that there are restrictions and covenants and so on that have been breached, is it reasonable then to ask the seller to modify those restrictions before we go ahead? Because if I'd open up a sales agreement and I later discover this, what course of action do I have to say, look, you said this, but the drawing is saying this? Do we stop the sale completely? What is the course of action there? If a diagram or engineer's report shows that there are covenants that have been breached.
All right. I'm going to answer that, Mr. Johnson, is it?
Yes.
Okay. The agreement would set out what is to happen in the event that the vendor is unable to prove title, i.e., prove that is free from the encumbrances, like a breach of restricted covenant and so on. So there are different ways in which it can be worked out. One, the vendor can undertake to apply to the Supreme Court or what have you to remedy the breach, depending on what the breach is, up to the point of completion. Or the purchaser can say, all right, I'm willing to take on the property notwithstanding the breach and maybe seek to abate the price for the cost of applying to the court and what have you to remedy breach. Or it can well be that the purchaser, having found the breach, feels that they're no longer interested in the property and can rescind the agreement in accordance with the terms of the agreement without having to suffer any penalty for it, get back in the past. That's it.
Mhm.
So one, it depends on the nature of the breach and the appetite of the parties to resolve the matter.
Okay, thank you.
Excellent. Thank you for that question. Ms. Samuels?
Hi, yes, good afternoon. Thank you. Just trying to figure out the steps to take. So the parents died. The last parent died in, I think, like mid-80s, 1980s. There was no title to the land. There were at least 3 or 4 siblings living on the land. One sibling went and got a title with their name alone on it. The sibling died, and now the child of that sibling that died has more or less taken over and claimed ownership. So we're trying to figure out what steps can the siblings that are on the land take? What do they need to do?
Yes, I believe that. Yes, that's an interesting question, and but I'm sure the High Commissioner with his esteemed experience can answer that one pretty swiftly.
Personally, the sibling that obtained the registered title would be in an indefeasible position, meaning that that would end any previous claims to the property unless you can show fraud for which that person got that title. So the issues now are, since that title, what entitlement is the child of that sibling have to the property? You may or may not have an entitlement to it, and that of course depends on the estate. The person still alive? The one who has the title?
They died.
The one who got the title died.
Right, it would depend on what that estate is and the administration of that estate. And therefore, there is no such thing as family.
Were there attorneys involved, Ms. Samuel?
Say that again?
The attorneys, lawyers involved?
Not at this time, not at this time. So basically you're saying we need to figure out the child that is of that dead person that had the title. Need to figure out, was it transferred to them, or is that what you're saying?
Never. What I'm saying is the person who is dead, whose name is on the title as a registered owner, you need to administer that estate to find out who is entitled to the land. That is what I'm saying.
And so who do we go to do that?
Well, did that person leave a will?
We don't know.
Okay. And if you don't know, I suppose you have to proceed as if there is no will. And it means person who is entitled under certain rules to administer the estate. Because it's of intestacy. Meaning, in the first instance, husband or wife will survive. In the absence of husband or wife, it will be eldest child. In the absence of eldest child, it is the grandparents. In the absence of the grandparents, then you may go to aunts and nieces. So there needs to be somebody in the family who will sit down and look at that deceased person and look at what their family structure is. There's a form that can be filled out that is issued by the Administrator General's Department in Jamaica that will assist in discovering who has the right to take out letters of administration in that estate.
May I?
Yes, yes, please, Mr. Young.
This question is a little bit more technical though, in the sense that the property was not in the exclusive possession of the registered proprietor, but it was in the possession of the other siblings also. So even though it was titled to A, the other siblings were exercising possession. So it appears that though the land was titled in its entirety to A, B, C, and D might be occupying their respective portions. And as such, that is a limb on which they could possibly state that they had exclusive possession over their portion, dependent on the circumstances. And it might very well put them in a stronger position should the daughter, who is the beneficiary in the registered proprietor's estate, be uncooperative.
Well said.
Okay. Okay, thank you, because they have been living on the land all this time, very much. And the one who got her name on the title, they weren't aware of it until years later. So,
Well,
so they all need to go talk to the Administrator General. Okay. Thank you.
You're very welcome.
Go back to
Yeah.
the, can go back to the chat. There's some questions.
We can take one more question.
No, he has asked a question before,
Okay.
and we have quite a few in the chat
Okay.
still. Angie?
Yeah. And in fact, this is also from Live Radio. Where someone claims to be the title owner, how can you confirm this and also to establish that all taxes have been paid before proceeding?
So in terms of locating the title, then we have the National Land Agency where you can make that inquiry online. And I believe, Mr. Young, it's the e-land service can be used as well. Correct? You can utilize the service. You can make a request under the National Land Agency. And the other second half.
All right.
And in relation to the payment of taxes again, this can be facilitated online once you have your reference number. And if you don't, then you can make inquiries based on the title. Yeah, based on the title number and the roll number, you can make inquiries.
Okay.
Just looking through some more, see if there's any other questions that can be answered. We got a couple of questions.
No questions on the YouTube, but there is one. I have a plot of land with an inhabited building on the land, plus a piece of land was given to my brother, and he built a house on the land. He has passed away. I now wish to sell the land and property, but one of his children is living on the land. Does he have the right to the land or property? All taxes was and is being paid by myself. What is the legal advice for me going forward?
Who asked that question?
Dawn.
Dawn.
Dawn. Good evening, Dawn.
Good evening.
Good evening to you. Yes, you've asked a question that really needs to be dealt with by perhaps instructing an attorney at law who can actually give you that definitive advice. Okay, so even though we could perhaps give you an overview, but because of the circumstances, it wouldn't be prudent for us to give you that full advice. But if Mr. Young wishes to add anything or make any suggestions, perhaps he can assist you.
I won't say much, but I'll say this. Paying the taxes doesn't give you the exclusivity that you all think. And I realize that that is a common misconception. Because possession is what is important. However, in this instance, the fact that the brother built the structure, he would have a live interest in the property, and he's dead, which would mean that his estate should be administered or his will probated. So his son, who is living there, now has an interest, and if he had a wife and so forth. So it is a question that cannot, as counsel said, cannot be best answered here. So I would say explore the alternatives of speaking to counsel and so you can be properly guided.
Absolutely, and you know, we'd be in a better position to unpick your scenario and give you the correct advice. Or
Can
whichever attorney you utilize, you use.
can I add some information, please? Would that help? I do have the title and I'm the administrator. It's been probated. It has been willed by my mom, who has passed away. And we have been trying to do this for some time. Obviously there was oppositions, and we still would like to do this. So that is the situation at the moment, but there has been slight difficulties from the family member.
Okay. So what I would suggest to you, Dawn, is to instruct an attorney who can give you that you know, proper guidance that you need. All right.
Okay, thank you very much for your.
So welcome. You're so welcome. I think we're going to take one more question, and then we're going to have some closing remarks. So.
Okay, this last question, well, it's from Seymour. Our land has been obtained by a person in Jamaica through adverse possession, where he signed a declaration that he is my mother's nephew, which is false, as he is unrelated. Is it fraud or a criminal offense in Jamaica? In the UK, it would be classed as fraud. What advice can you give?
So, Mr. Young, will this go beyond the adjudication service that is provided for at the NNA?
This is an issue of contention, and as such, they would have to retain counsel to approach the court. Because any misstatement made in your declarations is considered to be fraudulent, treated as fraudulent. So that would be their option for the court to decide. However, for adjudication, if it is that there is a dispute and the persons are open to having the matter being heard in that setting, then the committees usually look into it and arrive at a decision. However, if a party is dissatisfied, they can still proceed to court.
The recourse would be to go down the avenue of the court process.
Just really briefly, just to say that I should insert myself.
No.
The declaration that is untrue would be perjury under Jamaican law as it is here, I'm sure, in the UK. However, not all frauds will lead to a title being struck down. So even though the declaration may be fraudulent, that doesn't mean that you ipso facto that your title will be challenged. So again, sorry to say, you probably should engage in attorney.
I hope that's answered your question. We have 2 hands up, and we're going to take these last 2 questions. Hopefully we can respond.
There's Kingsley Douglas.
Yes, Mr. Douglas, welcome.
Hi, good evening. I'm in the UK, and I've posted a couple of questions in there, but you haven't got around to them. But what I'd like to know is, if I have the valuation and the volume and the folio, can I actually get the surveyor to have a look at that land and survey the land for me? And secondly, in the adjudication of the land and ownership, do I have to be in the UK to actually sit before the committee to verify the land ownership?
In Jamaica. I think
to answer your first question, yes.
Mm-hmm.
And to your second question, I'm not sure if the adjudication panel is can be heard virtually, but Mr. Young can assist with that answer.
Okay, thanks. Yeah.
Thank you for your question. Once it is made known that the person is outside of the jurisdiction, they will hear your evidence via Skype or WhatsApp call or any of the other platforms that they can utilize. But your two supporting declarants, or even one of them, must be present or must be available, even if the applicant is out of the jurisdiction. Also, for counsel, counsel can appear on the behalf of their client if their client is unavailable. So it's quite flexible.
Okay, thank you.
So you're welcome.
And Pastor Kevin John.
Hello, good evening. I just wanted to find out, are you actually going to conclude the meeting now, or are you going to talk about other things? Because I wanted to talk about transfer of title. So I don't know if that's going to be another discussion. If not, I'll ask my question now, or maybe you're going to address it later on.
You can ask a question and we can.
Oh, okay. It's very simple then. If a person wanted to transfer their land title to another person, what is the process?
Let's going. Would you
That's
like
it.
to...
Sorry, say that again?
No, I'm just handing over to my colleague.
Okay.
Depending on the circumstances, if there's no money is being transferred,
Yeah.
no money being passed over.
Right, there's no money being transferred over. It's simply giving the land over title over to somebody else, to another family member. Yeah.
That can be done. Yes.
I'd just like to know how it can be done, basically.
Yeah, well, we call it a love and affection transfer. You prepare the transfer. You'll have to do a statutory declaration to say what the value of the property is so that they can assess transfer tax and stamp duty. Submit those to the stamp office. And once you have that, you then stamp up the lawyer will stamp up get the transfer tax certificate, stamp up the transfer and submit it to the titles office along with the VCT, the get certificate of title. That's essentially the process. Of course, if it's a husband and wife and what have you, and they can seek some sort of exemption from the transfer tax, then it's otherwise you're going to be paying transfer tax.
Okay. Thank you very much for that.
You're very welcome. So do see.
And then quickly adding to what senior counsel said, if it is that the transfer is not for consideration and you can show the familiar line, husband to wife, father adding children, etc., maybe grandmother adding grandchildren, through the Land Administration Management Division under the SPA, we can waive the relevant duties. And so the matter is sometimes assessed. However, you won't be paying any duties. All of these duties will be waived.
Okay.
You will pay a cost, an administrative cost to the NLA for the duties to be waived. But it's not a case where, let's say, your property value is 30 million and you're paying transfer tax against that value. So it will be waived. So that's something that you can explore, provided that the property, the transfer is not for consideration.
But just maybe clarify it a little bit. It's cousin given to a cousin, basically.
Once you're able to show the link or the connection, it is practical.
That's fine. Wonderful. Thank you.
Okay, wonderful. So we've had, so many questions have been answered and tackled, and we sincerely hope that you have enjoyed and taken away some golden nuggets from this session this evening, entitled "It's All About Land." Thank you to our presenters, and I'm now going to hand over to Mrs. Patrice Lard-Grant, who is our Deputy High Commissioner, for her closing remarks. Thank you.
Right, thank you so much. And it is my duty this evening just to extend thanks on behalf of the Jamaican High Commission to all concerned. I want to thank first and foremost His Excellency, Sir Alexander. Right? Now,
Definitely.
he established himself as a senior counsel. And so we look at the High Commission. And if you do encounter him along his many sojourns throughout the UK, that you may actually put him aside and have about some of your legal concerns. But also we wish to thank Mr. Nicoy Young, Miss Nastasia Bowen, as well as Miss Simone Bowman for anchoring this segment. We will have another segment early next year, which will focus on wills. Yes, right. And thank you so much for being with us this afternoon. We are sorry that we didn't have more time, but you can understand that given the hour and various commitments, that we were able to benefit greatly from invaluable advice from colleagues here. I also want to thank Mrs. Vivian Sieber, Community Relations Officer, and the rest of the team here at Jamaican High Commission for facilitating this engagement this evening, as well as to thank you, our participants, for joining us and for so engaging with us through your questions and comments. Thank you, and we look forward to another session, which we'll be having in early 2024. Thank you, and good night.